And now we're going to our next speaker, which will be Dominique Inchauspe. Dominique graduated from the University of Paris in Masters 1, 2, and first year of law. He obtained his doctorate in 1981. He briefly worked as a chartered accountant and then was drafted for 1 year in the French army. Following his military commitment, he started practicing criminal law, mainly practicing common crime defense, such as murder, drug trafficking, and so on. Between 1989 and 1990, he was invited to join a team of African lawyers in Mali for a trial of the former dictator. He later found himself traveling and working in El Salvador, Azerbaijan, and other parts of Africa, including working on sensitive cases in Gabon. With ISIS emergence and the eventual collapse, he traveled to Syria and also worked with the Syrian Kurdish representatives in Paris on how to lodge criminal and terrorism-related cases before French, EU, and UN courts, including on how to set up an international anti-terrorism court. Dominique is the author of several books, including Miscarriage of Justice in 2010, and also French translation of the UK Habeas Corpus Act of 1679. A major part of his work is dedicated to a comparison between French and US, UK, and Canadian criminal proceedings, especially with regards to miscarriages of justice and the gathering of evidence. He is a registered on the defense lawyers of the ICC. He is also a lecturer at the University of Paris, fraud, offense case law, and at the National Gendarmerie Academy. An introduction to the US, UK, Canada, French criminal proceedings and comparison. He is also a scientific director of one of the French criminal law encyclopedias. Mr. Inchauspe, your comments. You're on mute.
I am not mute anymore. Is it okay?
Yes, we hear you.
Thank you for coming to Paris and visit me, and I can see Notre Dame through this window. I am going to address a few considerations on legal perspective, okay, about repatriation, especially in France. We faced a big problem here in France because the public, the people are not interested at all in getting back our French fighters in north of Syria and also their children. Imagine that there was a poll recently, 82% of the French people are against the coming back, the repatriation of fighters in Syria, and 67% are also against the repatriation of children. And we had recently a few dozen of children repatriated from north of Syria, but that's all. In practice, we face two channels, two types of problem. The first one is the guys who are still in jail in some Kurdish camps in north of Syria. These persons, fighters, women and children, the French people, the French government do not want them back in France. So, and I have some lawyers of mine who are trying to get a move from the French justice and the French government, and they couldn't succeed by now. One of them has lodged a claim against the Minister of the Interior before a special court, la Cour de Justice de la République. Nothing happened. He just lodged another claim for kidnapping and abduction before the Criminal Court of Paris, and the case is only starting. Another one, a lady has published a book to say that this is a shame that the children has abandoned in north of Syria. Okay, so we have some big problem. The second channel is that what we call the Cazeneuve Agreement of 2014. The Cazeneuve Agreement is from the name of the Minister of Interior by that time, Monsieur Cazeneuve, and this is an agreement between France and Turkey in order to organize the way that when some people escaped from camp in North of Syria and came to Turkey, when they are French, the Turkish authorities call the French government, some French police officers come to Turkey, take the guy back and bring them back in France. It seems that since 2014, there are almost 300 adults people who came back, among them 110 women and plus 152 children back through this Turkish channel because they are arrested in practice in Turkey. But all the prisoners still in camp in North of Syria, we do not want them. So we face a big problem about that. When the guys, through the Turkish channel, arrive in France, they are split. Children are put in some social service administration, and the adults, men and also women, are charged with usually with the offense of criminal conspiracy, especially the women. They are supposed to have been very close to their husband, but they are supposed not to have participated to the crimes. So they are charged with the criminal conspiracy. Maximum penalty is 10 years. Okay. We have another case very interesting in Belgium, where two ladies in a camp in North of Syria, first of all, were sentenced in absentia to 5 years imprisonment jail. And they have asked the Belgian authorities to come back with their children. The first court in Belgium say, okay. The second court, the Court of Appeal, say, no, we do not want that. So this is a summing up of the way the Western countries in Europe are dealing with this with the repatriation problem, okay? Alors, now I address some specific issue about a very important point, the gathering of evidence, okay? In the French justice, in the justice which come from the French justice, like the Belgian one, the evidence is free. We do not have any admissibility problem like in the UK, US, and Canadian system. We do not have an assessment of whether an evidence can be put or not in a case. We gather everything, we put it in the file, even when we speak of hearsay evidence. And then the examining judge and the judging judge are making their inner conviction. So it is very easy for us to check an evidence. It is less evident to check, to gather the evidence, but when we get any piece of evidence, it is put in the file. So it is easy to issue or to return a sentence because anything can be an evidence and it is put in front of the inner conviction of the judge. So the French criminal justice, related to the evidence problem, is wide open, okay? Voilà, so these are very important to me, very important consideration. I can add, and I will finish about that, I have worked a little bit about the possibility of an international anti-terrorist courts, which could be set up in north of Syria. And in my opinion, the best way would be not to create a new international court because it is very complicated according to United Nations decision, etc., etc. We could do what the Kosovo, for instance, does. This is specialist chambers put in an already existing justice system. And in north of Syria, there is already a justice system, And myself, I have visited, when I was there in July, I have visited the anti-terrorist court in Amuda, which was in charge of judging some terrorist fighters, and they already have a special law dated 2014, which make them available to make any legal decision. I am not in favor of setting up a new international court dedicated to this judgment. Voilà. It is over. I have finished my small assessment.